Okay, class. Chapter 1, Part 5. Okay, we're talking about now controlling precedence. And what does that mean, controlling precedence? Well, remember the concept of precedent, which is that a court sets a principle of law, usually it's a higher court, and then lower courts under that court have to follow that principle of law to give stability to the law. So a controlling precedent is a binding authority in any source of law that a court must follow in deciding a case. Okay. The types of legal authority. Binding authority is any source of law a court must follow when deciding a case. And it includes all, of course, of the primary sources of law, which are constitutions, statutes, and common law. It's also often called mandatory authority or mandatory primary authority. Okay? You want to be able to reference to the court, or as we say in the law, cite to the court, mandatory primary authority, because it forces the court to have to follow that rule of law. It doesn't give the judge any choice in the matter, really, so that we avoid prejudice and individual decisions as opposed to a uniform system. Okay? Persuasive authority is any primary or secondary source of law that a court may consult for guidance but is not binding on the court. So we know that secondary sources of law include things like treatises, which are learned scholarly books, encyclopedias of law, those kind of things. But a primary persuasive authority would be a constitution, a statute, or common law from another jurisdiction, another state, for example. So in Georgia, a statute in Alabama or a case opinion from a court of appeals in Alabama would not be binding authority on the court in Georgia, but would be persuasive authority. Where does persuasive authority come into play? Usually when there is no applicable law in the jurisdiction that you're in. So if you're in a Georgia Superior Court and the case that's presented is one that we call a case of first impression, that is that there's never been a legal decision or a statute or constitutional provision that applies, then the court may look to persuasive authority from another jurisdiction, such as another state. The reason for that is usually the other jurisdiction has thought through the issue, and that thought process and that rationale will be useful to the court. The court does not have to follow it. That's why it's called persuasive. Okay, so obviously persuasive authority is only occasionally necessary, because most of the time you should have binding authority and you should have mandatory binding authority. So here we see, as I said, first impression situations. Now, there are rare situations where an appellate court can deviate from precedent. Those situations are where the court determines that the precedent was obviously incorrect, and that's sort of second-guessing the previous court, so it doesn't happen very often, or there have been technological or social changes that have rendered the precedent inapplicable. An example of that is probably Roe v. Wade, which we'll talk about later, but Roe v. Wade was decided in the 1970s. Then, about 10-15 years ago, the court decided a subsequent case called Casey versus Pennsylvania. The Casey court modified the Roe decision based upon the court's opinion that science, particularly the science dealing with pregnancies and the development of a fetus, had changed, making parts of Roe no longer a good law. So it was modified. Okay. So all of this plays into what we call the rule of law, which is the idea that courts, judges have to follow precedent, and that they take an oath to do so. It's what separates our judicial system from a lot of other judicial systems, particularly those in third world countries, where you go before a court and the judge can basically do whatever they want to do. That's unfair, does not provide for equal justice, in many cases doesn't provide for any kind of justice. So we look at ourselves as the leader in this area, and you often hear people talk about establishing the rule of law in some of these third world countries in order to make them more modern and more stable. Okay, so we're going to stop there and we'll pick back up with the next topic, which is legal reasoning.